of the 120,000 Japanese and Japanese Americans who were subject to the discriminatory concentration camps and other measures, only 12 openly resisted.
Fred Korematsu ends up being caught on a street corner.
He was apprehended in San Leandro, California. He was tried and convicted.
And he challenged the legality, the constitutionality of his order to report to an assembly center.
He was at the same time standing up for the rights of every single one of those 120,000 souls who were equally unjustifiably treated.
My admiration for someone who had the stubbornness, the willingness to be idiosyncratic, the willingness to rebel, despite the fact that his community, the Japanese community as well as the public, were supporting this large movement in the name of patriotism during World War II. And so it really took an incredible individual.
I believe in the 1950s, Fred Korematsu's daughter came home from school and said they talked about a case involving someone named Korematsu in their history class. And she wondered, well, look, are we related to this Korematsu? And so he had to say, well, yes, that was me.
Franklin Delano Roosevelt issued Executive Order 9066 on February 19, 1942.
The rationale behind the policy was one of national security, in particular a fear that the West Coast would be invaded.
Japanese nationalism among ethnic Japanese in America was quite high and demonstrated in the amount of money raised for the Japanese war effort and support for Japanese militarism generally. So for American policymakers, including the military, there was sort of an expectation that the majority of our ethnic Japanese would be sympathetic toward Japan.
The order basically gave authority to military commanders to issue orders that could exclude persons from areas that they designated.
Shortly after the executive order was issued, Congress, by overwhelming bipartisan vote, passed legislation that implemented the executive order and also created criminal penalties for anybody who violated not only the order itself, but more particularly regulations that were issued by military authorities under the order.
There is a clear distinction between relocation and internment, though many writers blur that. Relocation is what befell most of the Japanese Americans and the other ethnic Japanese. My father, a resident alien, was not interned. He was relocated, however.
The executive order itself simply created exclusion zones. And just as the executive order delicately avoided saying who would be excluded, it also strategically avoided saying what would happen to the excluded people.
Relocation was forced upon roughly 90% of the Japanese on the West Coast.
They were absolutely unable to find other places to live. Other states issued decrees from the governors and other officials saying Japanese Americans are not welcome here. They used much less diplomatic language than that, using racist slurs. And so the only place to put these excluded individuals were these camps.
There was work, they were paid for it. They were actually encouraged to leave the centers. After a few months, they could get passes to leave. My parents would leave on weekends. These residents could get out if they could attend a college that was not in the relocation zone. It's not as though they were there on extended summer camp or something like that. That would overlook the harshness of the conditions.
It was frightening for those who were facing a series of orders, basically because over a relatively short period of time, they had to make plans and to report with no knowledge as to what the future would hold.
We are talking about horrifyingly huge numbers. By far the largest number of people who have ever been detained, imprisoned in concentration camps in United States history. About 2/3 were full-fledged American citizens who had been born in this country. Some were third generation in this country.
And as a result of that, you had massive losses in terms of property losses.
Houses had to be sold. Of course, my parents had to give up their business and leave. My parents wound up in the Puyallup Fairgrounds outside of Tacoma, where they were housed temporarily while the relocation centers were being built.
My dad, for example, lived in Merced, California, a central California community. And he and his family were required to report to the Merced County Fairground area and to be housed there on a temporary basis. The assembly centers were often at fairgrounds, where they used the stalls of animals, basically, to create rooms for families to reside in.
After the segregation order, my parents were sent to Minidoka, which was a camp in Idaho. It was made a segregation center because the ethnic Japanese often treated their fellow camp inmates who were vocally pro-American as traitors to Japan, and they would often inflict acts of violence on them.
Every single one of these camps was in an extremely dangerous, unpleasant, grim, difficult, challenging environment. The conditions of confinement were horrific, lacking basic comforts and safety provisions. A number of the people were killed merely for having allegedly walked too far beyond the barracks. Fred Korematsu was a 23-year-old American citizen who had been born in this country to parents who had immigrated from Japan many years ago.
Fred Korematsu worked in San Leandro. He was a welder.
Fred was a patriotic American, and when it became clear that the United States was likely to go to war, he learned the welding trade, believing that that would make him of greater service to his native country.
After the military orders came out, Fred Korematsu engaged in a series of acts which actually displayed his unusual nature.
And he did not want to go into a concentration camp, so he took extraordinary steps to try to avoid this unjust ruling.
He took on the name of Clyde Sarah and altered his draft card to have that name.
He had minor eye surgery so that his eyes would not look Japanese, quote unquote.
His friends recognized him immediately, so he was arrested.
Fred Korematsu ended up litigating his case because shortly after being imprisoned, he was approached by someone who belonged to the ACLU in the San Francisco Bay Area.
We were the only national organization in the entire country that opposed this order in any way.
The case went from the trial court, which imposed the criminal conviction for a willful violation of the statute that supported the military order, going to the Federal Court of Appeals, which upheld the criminal conviction, and then finally onto the U.S. Supreme Court. When the Korematsu case came to the Supreme Court, there was already the Hirabayashi case as precedent. Hirabayashi challenged that curfew and in a similar way was convicted. And in that case that went before the Supreme Court upheld the power, the authority of the military commander to impose this curfew on national security grounds.
What's often not appreciated about Korematsu is that it occurred so late in the war.
Korematsu's arguments largely rested upon his individual rights. He claimed due process rights, he claimed equal protection violations, a violation of search and seizure, and his claim was that the violation of these constitutional rights should mean that his criminal conviction should be overturned.
The United States Supreme Court decision in the Korematsu case was split 6-3. But what's really interesting is that all 9 justices, the 6 in the majority and the 3 in the dissent, agreed on the legal principles. What they disagreed on were the facts and therefore how the legal principles applied to the pertinent facts.
The government relied very heavily on the earlier outcome of the Hirabayashi case. It was however, a kind of dilemma in that there was a final report that had been issued by the Army. The Army, in its final report, had concluded that there was significant evidence pointing to a national security threat by the Japanese communities, whereas the Navy intelligence reports concluded that there was an overmagnification by the public and others in the military of the national security threat.
There was evidence of the lack of such danger that not only was not presented to the court by the government, but worse yet, we now know that officials within the Justice Department complained about the failure of the Solicitor General of the United States, who signed the brief for the United States, who made the oral argument before the Supreme Court, refused to present the evidence that there was no military justification.
Solicitor General Fahey was responsible for the final footnote 2 in the government's briefs that said basically that the court should rely upon the Army's final report only for its description of the internment and the actions that occurred after that.
I think Fahey's significance is overrated. I guess the charge is that he suppressed a lot of information about the loyalty of ethnic Japanese that might have swung the opinion of the court the other way. I think it's a red herring, though, because Justice Black, in his opinion, cited enough information to justify relocation, and he cited instances of self-proclaimed Japanese patriotism. What would one think of a group of people who proclaimed their support for the 9/11 attackers in the United States?
The majority opinion in the Korematsu case was written by Justice Black, and it upheld the military order to the Assembly Center. It was very careful in saying that it was only addressing the exclusion order that forced the Japanese to report to the Assembly Centers. Its ruling did not apply to the actual internment camps themselves. And then it goes on to state basically that it was important for the government in terms of its war powers to be successful. And it pointed out that in this case, you had harmony between the military order, the executive order, and the legislation by Congress.
And of course, Black never mentioned the Ni Hao episode, where you had a case of a Japanese American who pledged his loyalty to this Japanese pilot who happened to land on this obscure island in the Hawaiian archipelago. One of the great unwritten stories of World War II is the effect this bizarre episode had on the military and national security planners generally.
There was a dissent by Justice Roberts, which looked at it from a due process standpoint and concluded that there was insufficient due process here. The dissent that is most widely quoted and known is a dissent by Justice Murphy. Justice Murphy applied a pretty straightforward application of what we call a rationality test. In this instance, he would require that the government action have a reasonable basis. And he did a fairly comprehensive analysis of the facts that were before the court, including the final report by the Army, and concluded, based upon those known facts, that there was no significant threat established by the government. And based on that, there was no rational basis.
He said that we are approaching the abyss of racism, and he actually compared the United States action to how the Nazis were treating Jews and other minorities.
The thrust of Justice Jackson's dissent seems to be aimed at the fact that he really felt that the military and the civilian spheres should be kept apart, and that if the civilian spheres included judicial decisions involving military orders, that would create a bad precedent that might have a deleterious effect on future individual rights.
I would emphasize that the focus on the Korematsu case really distorts its legal significance.
One gets a general sense that what Justice Black was trying to do was to minimize the opinion itself. Because on the same day that Korematsu was issued, there was another legal case that was issued by the U.S. Supreme Court, a case called Endo.
Korematsu should never be mentioned, especially by its critics, without also mention of ex parte Endo.
There, unanimously, the court held that an American citizen who was a loyal citizen, no individual evidence of disloyalty, could not be detained. So that meant that at least all of the American citizens who were in these camps had a legal right to be released. Ms. Endo was somebody who, like Fred Korematsu, bravely challenged the discriminatory treatment, but she used a different strategy. She did report to a detention center, aka concentration camp, and then challenged her imprisonment under the writ of habeas corpus, which is the constitutional provision that allows anyone to challenge any detention by the government as lacking in procedural or substantive justice.
And its holding was that based upon the statute, that a U.S. citizen, Endo, could not continue to be held in an internment camp since the government conceded in the Endo case that she was not disloyal. And so based upon the statute, Endo needed to be released. Also, just before the court announced the Korematsu case and the Endo cases, the president had announced the end of the Japanese internment itself.
They were not actually released, however, until early the next year, 1945. And the camps, one of the camps stayed open until quite far into 1946.
The political aspect of this was that Franklin Roosevelt wanted to hold off the announcing of the decision until after the 1944 presidential and other elections.
After the court handed down its opinion upholding Fred's criminal conviction, he had been transferred from his prison to an internment camp to stay with his family, who was already there. After the internment was over, he decided to go to Detroit, and he lived for a while in Detroit, and within several years married a woman from South Carolina. He then eventually returned back to the San Francisco Bay Area, where he worked as a drafter for some small local companies. Fred Korematsu's conviction was overturned in 1983 by a federal district court in San Francisco. The Asian Law Caucus decided that it would bring forward actions based upon an ancient legal writ called a writ of quorum nobis. Under this writ, what the Asian Law Caucus alleged was that the government hid information from the U.S. Supreme Court in the original case of Korematsu.
So the convictions were vacated, stricken from the record. Notably, though, the judge in that case had no power to overturn the Supreme Court decision.
So we can ask, well, what remains of Korematsu?
There has been no case that has specifically addressed the issue like Korematsu or Hirabayashi in terms of requiring the exclusion or the internment of people based upon race.
In Trump v. Hawaii, Justice Roberts, it was argued, may have actually overruled it. I don't think that's the case. Specifically, what he said is that it was wrong the day it was decided, and it has been overruled by the court of history. Now, of course, Chief Justice Roberts is Chief Justice of the Supreme Court, but I don't think he's the Chief Justice of the Court of History, whatever that might mean.
Interestingly enough, constitutional law professors and other experts are debating, as we always debate about everything, whether that literally constituted an official overruling of Korematsu or not. Therefore, conceivably, as Justice Jackson warned in his dissent in Korematsu, it might still be lying around like a loaded weapon to be brought out next time we have national panic and seek to target a particular feared minority group.
I think the Japanese relocation was really a one-off, but that there are powerful emotions of loyalty and often disputed loyalty. That should always be kept in mind.
I personally am in disagreement of that. I think that in times of war, especially in an age of terrorism, there is always that possibility that extreme measures might be taken by the government in response to strong felt need.
We are never safe because the current danger, the one that is threatening us right here, right now, is always going to be seen as being different and distinguishable from what went before.